We're going to be talking about employment tribunals. So we're
Oh,
going to
good.
start really basic and then we're going to build out. Okay.
Okay,
So
good.
I'm going to kick off with the first question.
Yeah.
What is an employment tribunal?
Right. Okay. So when you start a claim against your employer, a worker can bring a case against the employer for unfair dismissal, wrongful dismissal, discrimination, loads of things. You,
Yeah.
it's the only place you can bring such a claim, with the odd exception, is it within the employment tribunal.
So who can make a claim at an employment tribunal?
Right. Okay. So a worker can bring a claim, but to simplify things, it's
Yeah.
usually an employee. Now, an employer can as well, but it's
Yeah.
very, very rare, very, very rare if an employee is in breach of contract that has cost the employer a lot of money. But I think on the whole, in tribunals tend not to like that. So
Yeah.
it's the employee brings a claim against the employer for alleged wrongdoing by the employer. And let me qualify what I mean by employer,
Yeah.
because the employer is intangible. You can't go out and touch the employer. So when we say employer, we are talking about employees of the employer, or it could be the director,
Yeah.
and for whom the employer is liable.
Yeah.
So
So for
you
example, it could be the manager,
could
for
be the
example, the
manager. Yeah,
employee's line manager.
absolutely, absolutely. And in some circumstances, you can bring the case against the manager as well.
Yeah.
So you
People
can
tend
bring
to
both.
forget that.
Yeah, as well, as well.
Yeah.
There's some you clearly can't. So, for example, you can't bring unfair dismissal against the manager because the manager doesn't employ you.
Yeah.
But if it's discrimination, for example, you can bring it both against the manager and against the employer.
Okay.
Yeah,
Be watchful, especially around.
absolutely, absolutely.
Okay. What types of problems can you bring to an employment tribunal?
Right. So there are a multitude of claims, but what's very important here, and
Mm,
to try and simplify this, there's something called cause of action. Now, we're not going to get too technical here, I know,
mm,
but what that means is that you could only bring claims that the law says you can bring. I
mm,
think a prime example I can give is this under the Equality Act. If you're being discriminated against,
mm.
has to be something that the law says is unlawful. So,
Yeah,
for example, if you bring a case that you were discriminated against because you are shorter than somebody else, the
mm,
law doesn't recognize at this point in time height has been a protected characteristic. So that's an example where the law doesn't recognize that. You put that down in your claim form, it's just going to be kicked out. However, if unless for some reason you can demonstrate that's related to protected characteristic, and it can be, for example, in sex discrimination, uh,
yeah,
if you were to say that the only people who can apply for this job must be 6 foot tall, there'll be many men can't make it, but probably more men can make it than women.
yeah.
So that could be this discriminatory. But you have to bring something that's recognized in law, that the law says you can bring, like discrimination on a protected characteristic, sex, race, disability, sexual orientation, all that kind of thing.
Okay.
So if it doesn't fit in with the law, you can't bring it.
We just get chucked out.
Just get chucked out. The law, so we don't reckon you brought something that we don't recognize in law. Sorry,
Oh,
Parliament haven't given you that right.
okay. Thank you. Um, do you have to pay to make a claim?
Right, you used to. Well, let's go back.
Mm-hmm.
It was free.
Mm-hmm.
Then it was brought. You had to pay,
Mm-hmm.
and then I can't remember who it was. One, I think it's one of the unions
Yeah,
successfully challenged that in
yeah,
court, because what it found was, in particular, that it was a barrier to some
yeah,
people. They just couldn't afford it to bring a claim, and then it became now it's free again.
yeah. How long do you have to make a claim after leaving a job, for example?
Wow, yes, good one, good one. Right. So the the general thing, there are some exceptions to this, but the general rule is within 3 months.
Mm-hmm.
It's within 3 months less one day, which is sometimes
Mm-hmm.
confusing to people.
Yeah,
So if they leave it to the last minute, they think the anniversary of the date they will dismiss. So if we were to take 3 months from January the 2nd, for example, February, March, April, people think it's the 2nd of April. No, it's not. It's the 1st of April.
Yeah.
So it's that less the one minus 1 day. But what I say to people is this:
Yeah.
don't work towards the last day.
Oh,
Get your draft claim and get it in. You don't have to wait till the last day. Get
yeah.
it in. If
Yeah.
you've got a claim, you think you've been unlawfully or wrongfully dismissed. What
Yeah.
are you waiting for the 3 months? What are you waiting 3 months for? Do it now.
Yeah.
Do it
Get
now.
the advice and put it in.
Precisely.
Okay.
Precisely. Put it in. If in doubt of anything, put more in.
Yes.
It's gonna be a lot harder if you don't put it in and then try to get it in later on.
Yeah.
Lot harder. So make sure you put more in. You don't have to have all the evidence. There are allegations. It's enough to bring a claim.
Yeah. You
Yeah.
just need to have the pertinent information there and
Yeah,
the deadline.
indeed. The evidence will come out later on. And
Yeah.
if, for example, you feel that an allegation you've made is unsustainable,
Yeah.
and you can just drop that allegation.
Yeah.
Might be you got four others that you think, yeah, I can run with these.
Yeah.
But the other way around is very hard. It's very hard if you brought four, if you brought, say, four, there's one more you could have brought in, but you think, I wasn't too sure.
Yeah.
The chances are you're not going to get it in.
Yeah. So better to err on the side of caution.
Put it in, it can come out.
Yeah.
Don't say I'll put it in later on because it might be out of time.
Yeah.
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 Okay. What is early conciliation and why is it
Right.
important?
Right. Yeah, yeah, very good. So before we had the so to answer your question about the within the 3 months, the dismissal. In the old days, you dismiss, like I said, on the 2nd of January, you need to bring your case by the 1st of April. However, now you have what's called the early conciliation. That's very complex. We can't go into how it works. All I
Yeah.
can say in simplistic terms, this is how it works.
Yeah.
You must notify ACAS before you can bring a claim.
Yeah.
Most cases, not every case, in most cases. So what you do, you go online, you online is some form, you say to ACAS, I've got a claim, this is a respective prospective employer. They contact you and say, do you want to try and settle this case using ACAS's services? Assuming you do, ACAS tries to facilitate that settlement agreement between the parties within, a maximum of 6 weeks.
Yeah.
If not, what ACAS then issue, not if not, but at some point, ACAS issue what's called a certificate, an ACAS certificate. And then that entitles you to then bring a claim to the employment tribunal. Without the ACAS certificate, you can't bring a claim. But that's not the end of the story. The 3 month less 1 day is paused during that ACAS period. So in other words, if the ACAS period takes 6 weeks, you add the 6 weeks onto the end.
Yeah.
It is, there are two technical times when that can happen. But the general rule of thumb is the length of time it takes for the ACAS conciliation period, because the parties may not agree a settlement, is the additional time you have. The clock stops and then starts again when the certificate's issued.
Okay. So we taped a video about settlement agreements earlier this morning. So you can get settlement agreement by way of the employer approaching the employee.
Yes.
Equally, the employee may approach the employer.
Yes.
Have a without prejudice discussion.
Yes.
But in terms of if someone goes through the early conciliation process, then ACAS can with both parties and come to a settlement agreement between both.
Yes, but there is a distinction.
Yeah.
An important distinction. So when you're talking about settlement agreement, you're not involving ACAS at all.
Yeah, no, not at that point. No, not at all.
But when you do involve ACAS, it's not a settlement agreement.
Okay.
It's called what's called a COP3.
Yeah.
So and the terms are usually a lot more simplistic.
Yeah.
So what you are doing with a settlement, so with a COP3, you're solely there to settle a claim.
Yeah.
That's that you're thinking of bringing within the employment tribunal. So that's settled. ACAS will help draft a few clauses and so on. I mean, if your lawyers are involved, I draft them, they draft them, and we give them to the other side.
Yeah.
So When ACAS is involved, it's a COT3. When
Mhm.
ACAS is not involved, it's a settlement agreement.
Yeah.
And a party doesn't need an independent legal advisor for
When it's
COT.
ACCAS.
They can just do it on their own.
Yeah.
And so on. That's effectively their choice. Usually, legal advisors not involved at that stage at all.
Yeah.
So yeah, so ACAS tried to facilitate, and I think the success rate with ACAS is actually quite high.
Yeah.
Yeah, so,
Yeah.
which is a good thing because it saves the parties incurring a lot of costs.
Yeah. And sometimes the employment tribunals are backed up.
Yeah, yeah, no,
Yeah.
indeed. And what you do have, which is unfortunate, I suppose. Well, it is unfortunate, but it could be fortunate, depending on how the circumstances are. You go to the employment tribunal and you still settle the case. You, after all,
After all that.
after all that, exactly. You spend 2 years working 18 because that's what it is these days. The unfortunate thing about it, you don't you don't. Although I mentioned the January and April,
Yeah.
you can bring your case, but the case could be heard next year or the following.
Yeah.
I mean, I got cases in my diary for 2027. So you could imagine that by the time both parties are fighting and so on, by the time you come to 2027,
Yeah.
I wouldn't say they've lost interest, but you can hardly remember when council put a question like, well, so just run by me, give me the exact words you used when you had this meeting on the
Yeah.
1st of March 2025. Dawn, I can tell you, I can't even remember what I did last week. I can
Yeah.
remember what I did over a few days ago, let alone 2 years ago. But yet, your evidence has been recorded of what you give. You can't obviously, well, in most cases, you can't remember.
Yeah.
I remember.
So it's really important for people to bear in mind as well the timescales and whether or not they're willing not just to go to employment tribunal, but they're willing to bear the costs
Absolutely.
of that timescale on them personally.
Yes, yes, indeed, indeed.
Yeah.
And also the will and desire
Mm.
in you with this because you've moved on.
Yeah.
You've moved
Maybe you're not mad anymore.
you know what? And that's a very good point because
Yeah.
as understandably, someone think they've been wronged, whether it's with
Yeah.
merit or without merit, they're angry.
Mm-hmm.
Are you angry? Sometimes 2 years later, you've moved on sometimes. And then you've got to go back, you've got to put yourself back into a situation, a mind frame of how
Mm-hmm.
you were 2 years previously when you were angry. And now you're looking at things, you think, oh, I can't be bothered now. I've moved
Yeah.
on.
Yeah.
And so yeah, it's one of those, it's a problem it's a court system generally. It's taking far too long to bring cases.
Yeah.
Far too long.
Right. So we talked a bit about what ACAS does in the early conciliation process. What is the ET1 form and what is it used for?
Right. So the ET1 is how you start a claim. That is your claim form.
Your
That's
claim.
where you put down what we call particulars of your claim.
Yeah.
You must put down the particulars of your claim so the respondent, normally the employer, knows what it is you are alleging that they have done wrong.
Yeah.
They need to know. That's vitally important.
Yeah.
As much as the employment system, the employment tribunal was once the industrial tribunal, and it was supposed to be very informal. Well, it's not informal now.
Mm-hmm.
There's all case law and all sorts of things. That's not
Yeah.
informal. So, and it doesn't mean because you're not wearing a wig and gown in the employment tribunal that you can just write any old thing down. No, it's very serious. If you don't mention it, you haven't pled it. You haven't pled it, it's not going to be heard by the employment tribunal. Don't say, oh, well, I thought I can just tell you, judge, when I turned up on a day that what I really meant was this. Nope, it's not going to work. I remember you and I having a conversation many years ago when I wrote a piece about pleading the case you want to bring.
I think it was 2018.
Really? Oh my
Now I'm looking back at my messages in my phone or
God.
I might be on LinkedIn, but I said, I remember talking to Ryan.
Yeah, that's
Make sure
right.
you plead the right
You've
case.
got to plead it. You can't come
Yeah.
out later on and say, oh, well, what I really meant, Judge, when I was watching Coronation Street was this. I was slightly distracted. No,
Yeah.
you got to plead the case you're going to bring. You want to bring. So
So
it's a
if
very
that's the
important.
case, just on another point, if that's the case, sorry, is it worth somebody speaking to somebody that's legally qualified
I
at
think,
that point? Because
yeah, yeah.
Otherwise, you might be wasting your time in essence, right?
Yeah, yeah, it is. I mean, there are some cases that are fairly clear
Yes.
in how you're going to write it. For example, if you're saying that the employer's giving you notice to leave and they've given you 1 month notice, and your contract says 3 months notice, you
Yeah.
should be able to articulate, look, I'm bringing a case. They gave me insufficient notice, and so on.
Yeah.
When you're talking about cases like discrimination, whistleblowing, they're very complex
Yeah.
because you're trying to find a causal link on, does this amount to whistleblowing? Is this a disclosure of information? There's case law around things like that. And
Yeah.
that's very, very complex.
Yeah.
Very, very complex. Discrimination, comparators, indirect discrimination is so complex. So yeah, if you can get advice, and it doesn't have to be, you're going to pay an employment lawyer as myself, go to CAB, go to a law center or somewhere and see if they can assist you. And there's some free bodies out there as well.
Yeah. And if you're a trade union member, you might be able to get some relief there as well.
Absolutely, absolutely. So there are bodies and people who can help you. But
Either way, it might be well worth the investment.
absolutely,
Yeah.
absolutely. Because if you go to the employment tribunal and later on it's not in there, then for the sake of, spending some time asking somebody, you could lose a chunk of your case.
Yeah. Yeah. Okay. And your mind.
Absolutely.
Okay. So what happens after you submit your ET1, your claim form?
Right. So once you submitted it to the tribunal then normally accepted your case. Now, that's not a judicial decision. That's just an admin one because you've got an ACAS certificate on the form. They know that you've done that thing. You submitted your ET1. Then what's an ET2 is something where it just tells the other side that your case has been accepted, well, case has been submitted, case has been accepted. But the 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 flip side, the opposite side of that is what's called the ET3.
Mm-hmm.
That's when the employment tribunal sends out the ET1 to the respondent, or there's respondents, it is more than one, and they then put their defense in.
Yeah.
So yeah, ET1 is what you send, the claim starts, ET3 is the defense.
Yeah. And the employer has to respond to that. Otherwise, it's
Right.
yeah.
Yes, they have to respond. Doesn't mean respond doesn't mean they have to necessarily defend the claim. It means they have to respond.
Yeah.
They may accept it.
Yeah.
My experience is very rare employers accept
Yeah.
it. But in theory, it can happen. In theory,
Yeah.
they have to respond and then plead their case in what they say happened.
Yeah.
Yeah, their version.
So, what is a case management hearing?
Right. That is something that was fairly, no, it's not fairly recent. It's been there for a while. So case management is after the ET1's gone in, ET3's gone in,
Mm-hmm.
you'll have what's called a case management preliminary hearing where the judge gets the parties together and try and iron out what are the issues, because sometimes it's not clear. It's not clear readings. And what the parties then agree with the judge is what's called a list of issues. What is it you are asking the tribunal? It's going to hear the case later on. What are you asking them to determine? The judge will then list all of the various things down. And then to give an example, the claimant says that she was treated less favorably because of her sex. The claimant relies on bang, 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 these four things.
Yeah.
Was the claimant treated this way? If the claimant was treated this way, was it because of her sex? And then so on. So that's the thing. That's clear now. So when the parties get to the tribunal, on top of that, in the case management hearing, the judge will give orders for disclosure, exchange of witness statements, who's going to prepare the bundle, and the date of the hearing.
Yeah.
So it's a full case management for that case to be heard whenever it's going to be heard.
So it's setting out the store, so to speak, and what's needed to make that store operational and clear.
Absolutely, absolutely. Yes, indeed, indeed.
What is the disclosure of documents?
Ah, right, I just mentioned that. So disclosure document is where both parties give to the other side all the documents that's relevant to the issues in the case.
Yeah.
Note that I said relevant and not all the ones that support your case. No, it's not just what supports your case. It can also be what goes against your case.
Yeah.
Anything that's relevant to the issues that's really been identified now in the list of issues, you send that to the other side, both parties. Then what the other side will do, the other side might say, well, actually, you referred to an email dated the 1st of December. In the email, the 1st of December, it refers to an email that someone's responding to. That hasn't been disclosed. I want to see that email as well.
Yeah.
So you request it. Now, when it comes to a point where both parties are happy that all these documents should form part of the bundle.
Yeah.
So that's what it is. It's parties effectively giving the other side all the documents they have in their possession. And so normally the employer will have more documents because the employer has the policies, have this, that.
Yeah.
The employee tends not to even have their contract. So, but yeah, so that's what it is.
And a bundle can mean several files, right?
Oh, it can be. Oh, absolutely.
Yeah.
Absolutely.
Depending on the issues.
Yeah.
So it can be a bit of a misnomer.
Yeah, there's a case that I'm awaiting a decision on at the moment, and that was 4 lever arch files. And believe me, that's hard to manage.
Yeah, because you're flipping through documents even when you're in tribunal, right? And you have to know where that document is that you want to refer to.
You have to know where that document is, and also, you might even have a separate document like medical evidence documents as well. And you have to be on top of it. Be on top of it.
And to that point, it's the same thing for the employees going to be sat in the tribunal. They need to have as intimate knowledge of that bundle. They're not necessarily legal knowledge, but they need to know their case really, really well.
They do. They do.
Yeah, they can't just relying on, no matter how brilliant your barrister may be, is not the most helpful thing to do to you.
You are absolutely right.
Yeah.
Because one of the problems, and I can understand how it comes about, one of the problems for employees, claimants, is that they feel because they live through the case, because they brought the case, they don't really need to read the bundles. No, you do.
Yeah.
You have to know the case exceptionally well, because one of the mistakes I think some people make, in like what you just said as well, the barrister does not give evidence. No matter how brilliant they may be, you're giving the evidence.
Yeah.
The barrister is trying to get what the barrister needs to get out, cross-examine on your behalf to put your case to the other side and do the rest. But they don't give evidence.
And you need to know the case. So when you hear something that seems off key or is not correct, you can alert your barrister, whoever it is that's supporting you.
Yes.
That's not correct. Or then you can flip to the bundle because you know what's in there.
Spot on.
So if you're an employee and you're really being smart about it, which I think most people want to be, is think of yourself as a partner to whoever is representing you. And the more you bring to the table, the more you can support your partner.
Indeed, absolutely. Because we take instructions, and that's precisely instructions. So we read things, but we read things in isolation. Sometimes the context is there. It jumps out, but many times, when you read something and you might say to a client, well, that's fairly straight. Doesn't that go against what you're saying? They said, no, because blah, blah, blah. Now, you would not know that unless the client tells you. So you need the client to give full instructions on what these things are. Now, when I'm preparing a case, normally, no matter how big the papers are, I like to have a minimum of 3 reads. So I read the first time open-minded, all the papers, I form no view. I very rarely make notes. The second one now, I know where the story's going. I've read it now. I know the beginning, middle, and the end. And then ideas are being formulated. By the time I do the third read, I'm preparing my cross-examination on that. But that's just a minimum of what I could be other reads as well. And by the time I've got to my second reading, I've asked my client a lot of questions. And what I like to do is that when we and we may come on to witness statements later on, but let's just stick with a disclosure. I like to ask my client to have any comments to make. Tell me, let me know now. So we say, that document so and so is this and that and the other. That helps. You don't have too much information. Never.
So you've got to be going to an employment tribunal. You've got to know what the almost count the cost. And it's not that you can anticipate every step.
Yeah.
But it's about being very, very clear that this is going to be a full-time endeavor.
Yes, absolutely. Yeah, indeed, indeed. And for some claimants, Dawn, it's very tough, and some employers as well, because some employees, and I don't want to give the impression that, because I represent a lot of employees as well, to give the impression that, you know, everything that's alleged against an employer is true. I mean, it's not the case at all.
No,
No,
no, no,
no.
no.
So,
And I've seen it both ways. So I've seen, you know, people considering whether or not they're going to the employment tribunal, and I've worked in the HR department. When
right,
that ET3 comes in, when you have to prepare that bundle,
right.
you know, as a HR professional, you have to prepare that bundle, and they don't play.
Yeah, yeah,
They want the information. They don't care whether or not you've mislaid it. That's a you problem.
yeah, 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 yeah.
You need to get it to us. And
Yeah.
also, I've seen the toll it takes on managers.
And
Um,
that's, yeah, absolutely, absolutely.
the thought of a claim, and
Yeah,
when lawyers come in
yeah,
and they're doing the witness, so they're speaking
yeah.
to, it could be managers, it could be employees, whoever's involved internally, and they're having to take that witness statement.
Yes.
So it's a huge cost, not just on the employee, but on everybody else that's involved.
Precisely, precisely. Yes, indeed. And that's the point I was going to make as well, because the employee sometimes, many times, are going back to a time when they want to recall something that wasn't very pleasant for them. It's difficult. The
Yeah.
employer is also having to recall something where they think they have done nothing wrong. You know,
Mm,
they may
genuine.
be a redundancy situation. They may be scoring, and you know, in good faith,
Yeah.
the claimant was at the bottom and made redundant.
Yeah.
And now they're being tested in ways I think, but I know I acted reasonably in good faith, blah, blah,
No.
blah. Sometimes it's not easy for them as well. It's not easy for
No.
the employer. So it is tough when you don't want to go to in a place in that space again, but you
Yeah.
have to for the employment tribunal.
Yeah.
You have to,
And
you have
that's
to.
why when I was advising managers,
Mm,
and you know, some managers wanted a particular outcome,
mm,
and I was always very clear because I've gone to give evidence on behalf of the employer a couple of times, and I
yeah,
always had this standard: if I'm going there, I want to be able to demonstrate X, Y, and Z.
yes.
I don't want anybody saying, well, why did you do this? And you can't give a reasonable answer. You
Sure.
can't demonstrate how you have acted reasonably. And
Yeah,
I just don't like the thought that I'm taking shame for anybody.
yes.
So, so and I was trained, you could end up in an employment tribunal at any time. So if you always act as though that's the case, you won't have a problem.
I
So when
agree.
ET3s used to come across my desk, it never engendered stress from my perspective. If
Mm,
anything, it was like, I've got to stop and get this bundle together.
yeah.
That was that was probably it for me. But if you've done it in good faith, I think that you have a different kind of stress where people are genuinely contrite and
Yeah.
second guessing themselves. But nonetheless, it's a stress burden.
Yes, yes, yeah. But no, you
You
are,
know full well
yeah, you
done
know,
a couple of things that you should have.
yeah, yeah, that you know those ones where an email comes to light where it's not very pleasant what you've written about the claimant. You think, oh, that's embarrassing, very embarrassing.
Yeah.
But yes, no, you have to be, if you've done things right throughout, in good faith.
Yes. Yes.
You ought not to have anything to worry about. It might be a tribunal decides, well, you know, this might be unfair, but you know, you can, what you don't want is that you've acted in bad faith and the
Yeah.
tribunal says, you know, and it comes out, because believe me, if you're
Yeah.
cross-examined by counsel, it's not gonna be pretty if you didn't do things that you should have done and you haven't done things properly. That's enough to keep people awake at night.
Yeah. I saw that in a case, Hastings versus King's College Hospital.
Right,
You
right.
read it.
No,
Um,
where?
the managers got chewed out. And I remember I was reading it, I was in an assessment centre at the time, and I was trying to read the judgment on the phone, which is never a good idea,
Yeah.
right? And I kept thinking, I mean, some of what happened in that case was outrageous anyway,
Hmm.
but I flipped through to the end, and what the judge said. about some of the managers. And what amuses me about how they never ever say you're a liar. They couch it in polite language, and I'm not sure which is worse. By the time they actually, I think one manager came out of that unscathed. One manager came out of that with good character.
Yeah.
That he could demonstrate that he acted professionally and fairly towards the claimant, but the rest of the managers, and I think people have just got to remember that these are public documents.
Yes.
Anyone can read, so make sure you're doing the right thing, because it may follow you when you go for another senior role.
Indeed, indeed. It didn't used to be public, but it is now.
Yeah.
I can search it and the names come up some, on searches.
Yeah.
Yeah, no, some tribunals have been very strong.
Yeah.
I think there's been wrongdoing by a party.
Yeah.
Some tribunals and judges let the party know about it in writing.
Yeah.
Not pretty at all. No, exactly.
They do it politely.
Oh yeah. Oh yes. It's with
It's very polite, but I don't. Sometimes I think it's sometimes worse. Just tell me what I did it wrong.
Yeah, yes,
Tell me, innit?
Indeed, yeah. That's just the way the profession works.
I know, but the way they do it, it always amuses me.
Yes. That's a skill and an art in itself. Yeah.
Okay, just a couple more questions for part one.
Right?
Okay. Can you bring witnesses to your tribunal hearing?
Yes, you can. You can. Yes. I mean, let's qualify by witnesses. You can call people to give evidence in your behalf, and they're called your witnesses.
Yeah.
So, and they give a witness statement, and there may be questions put to them on that statement. But you can also be accompanied by people at the employment tribunal. It's an open court.
Yeah.
There could be some restrictions on reporting, depending on the nature of the allegations, like heavy sexual harassment or something. You can have this X and B and A, and the person's name can't be reported. But yes, you can be accompanied in an open court, justice, open court.
But if you've got somebody that's acting as a witness that's relevant to your case.
Yes.
So say, for example, you're representing someone and they have witnesses that are relevant to their case. You would need to speak to those witnesses as well, wouldn't you?
Yes, absolutely. Yes.
And prepare them.
Yeah.
Similar to what you would do to the person that you're representing.
Absolutely. Yes. Because the person that you're representing, as far as the court's concerned, there are two hats they wear.
Yeah.
One hat is the person's a claimant or a respondent. Let's just say it's a claimant we're talking about here. The next hat is the claimant is a witness. So they're a witness in their own case.
Yes.
So somebody else is treated the same way as a witness.
Yeah.
Come along and they'll give witness evidence. Yeah. What is sometimes a difficulty for some claimants to comprehend is that they've been dismissed for say gross misconduct of some kind, and they've got loads of witnesses that are character witnesses. They tend not to assist very much because by its very nature, it's like naming a referee for a character reference. You're not going to bring someone along who's saying bad about you. Yeah. Tribunal is not going to say, right, you got 20 witnesses that says, Ryan's a wonderful person. He's very friendly. He's always, whenever I've given him 10p, he gives me 10p back.
Yeah.
But the employee is saying he stole something. No, I would never. He's never done that to me. Well, he's never done it to you, but you've done it to the employer. Yeah. So they don't really help character witnesses unless it's really relevant to the case.
You often see that in disciplinary hearings as well.
Yeah.
When people bring character witnesses and actually they don't impact the outcome.
No, they don't. They don't, because the character witness is nothing to do with whether or not you've committed the offence, the allegation. There's no bearing on it. There's no bearing, and no one's going to.
Sorry, I was going to say essentially make sure your witnesses are relevant to the points of your case.
Absolutely,
really relevant.
Absolutely, they've got to go to the heart of what's been alleged, what you're asking the tribunal to determine. And the tribunal may make findings that the employer fairly dismiss you, but the tribunal is not saying you're a bad person.
No.
It's
They
saying
just, it's that factual objective.
precisely.
Yeah. Yeah.
Precisely. And many times the judge says something like that. The judge says, look, I found against you, Mr. X, Miss Y, whatever it is. But he says, no judgment of your character. It's just
Yeah.
the employer could have dismissed you on the evidence he had before it. That's it. End of.
And I think that's a challenging hurdle for not just employers actually, but some employers to get over because it is a factual assessment.
It is a factual assessment. It's a
Yeah.
factual assessment based on the evidence before the tribunal on that day.
Yeah.
What I often say to people is that the tribunal make findings of fact.
Yeah.
Mean it actually happened. Findings of fact based on the evidence before them.
Yeah.
Their findings of fact may be incorrect factually, but that's the findings they make, and they were entitled to make based on the evidence that both the parties said is going to be before this tribunal. There's no point in going to the tribunal after the evidence. The tribunal made a finding of fact and say, actually, I've got evidence now to show that what you found was incorrect. The tribunal said, well, that's not the issue. You should have brought that before.
Which goes to the point whether or not you're the employer or the employee, you need to know what the details of your case are and that
Absolutely.
all the facts are available and you've spoken to your legal representative.
Yeah.
And, you're having those ongoing conversations because facts aren't always apparent. Something might happen and, someone says, oh, well, actually, that didn't happen. I've got this evidence to prove elsewhere. So it's about having that ongoing open dialogue.
Absolutely, because what the tribunal's doing, because the tribunal are in no better position than you and I to say
Yeah.
something happened or not.
Yeah.
So all the tribunal can say, based on this evidence, on the balance of probabilities, it
Yeah.
happened.
Yeah.
That's what it can say. It can't say it really happened. They don't know. They
Yeah.
don't know. So that's why what you've got to do is that having disclosed all the information, you've got to make sure as best you can that the evidence strongly supports your case.
Yeah.
So give the tribunal an easier decision to make in your favor.
Yeah.
Don't do it, then you got to face the consequences.
Yeah. So you've got to really dig into the facts, drop the emotions as far as possible. It doesn't mean that individual becomes emotionless,
No,
but they've got to look at their case and the facts of their case through the lens of a very objective, factual mindset. And that's a very difficult balance for people to make. But equally, having an emotionally driven mindset, I think, is worse.
yeah, it is difficult because a tribunal, you come back to what you said,
Yeah.
tribunal has to make the decision on the facts,
Facts.
not on the fact that at 1 minute past one you wept and cried
Yeah.
when some question was put to you. That's not, and don't get me wrong, I'm not saying if you feel the emotion, you cry, but the
Yeah.
tribunal is not going to find in your favor because of that.
Yeah.
It's based on the facts.
Yeah.
If you can, as much as possible, focus on answering the questions when it's put to you in cross-examination, and not what you think counsel is about to ask you. The amount of time someone's gave an answer to a question that wasn't put. Because
Yeah.
mind, and the worst one is when they say to counsel, "Oh, I know where you're going with this." It's
The
irrelevant.
witness says that.
Yeah, they say, I know where you're going, and counsel, well, you don't, because I haven't put it to you yet. You don't do it. That means you're thinking too hard ahead.
Yeah.
I'm not
Yeah.
listening to the question.
Yeah. I
So,
remember I used to read a lot of legal drama books, and I always remember when they were doing the coaching element, focus on what you are being asked.
yes,
Don't go to the left of it. Don't go to the right of it.
no, no,
What was you asked? What was the
absolutely.
question? And answer the question.
Yes,
Don't add to it. Answer the question.
you are right.
Yeah.
It's vital because someone in my position who's
Yeah.
done this so many times, and the judges listen to this, we look out for discrepancies, and trust me, if you give an answer to something that you thought I'd asked, and half an hour you say something's inconsistent, I will bring you back to that. And I will say, well, hold on, when I asked you this question earlier on, the learned judge will check his or her note to see if I'm correct, because I'm not allowed to mislead the court. You
Yeah.
say, hey, I'm asking you this question. Are you saying B? Which one is it?
Yeah.
So you've got to be very careful. And what often happens, there's a number of ways it can go. It could be a misunderstanding of the question. It could be someone's not telling the truth, of course. I mean, we're not that naive.
Yeah.
And it could be someone, it's not a misunderstanding, but they weren't thinking
Yeah.
about the
And it could be
question.
nerves.
It could be, of course, it can
Yeah.
be. Yes. And what is it? They've got something else in their head thinking that's the question that was put to them
Yeah.
because they're trying to second guess too much.
Yeah.
So they've given an answer, and it wasn't an answer to the question. They wasn't listening. They were focusing some of it. Yeah, nerves clearly comes into it as well. Yes.
So going to a tribunal, I mean, sometimes it's entirely appropriate, but it's not for the faint-hearted.
It's not.
No.
No, it's not. It's not. As much as it's something you've got to take into
Yeah.
the equation. You've got to.
Yeah.
You've got to think sometimes. My witness has maybe sometimes a compelling story. Sometimes there are nuances, there are grey areas.
Yeah.
And are they strong enough to articulate this in front of the judge or a panel of three members to bring it home?
Yeah. To
Time
land it.
they can't do it. You take someone who's, suffer from depression,
Mm.
anxiety. I mean, it's going to be very tough.
Yeah.
They're probably in front of their managers, let alone going in front of these three strangers
Yeah.
and being cross-examined.
Yeah.
The person that's cross-examining is not your friend.
No.
The person's your opponent representing his or her client.
Yeah.
It's tough.
And the goal is to win.
The goal is to win. Absolutely.
Yeah.
That's what you're paid to do.
Yeah.
So, you may not be up to it. You may feel you got something there. You've got a case. You may feel you've been wronged, and maybe you have been wronged.
Yeah.
But you also got to think, can you bring this home mentally?
Yes.
I mean, because it is very stressful.
Yeah. Can you bring it home mentally, and can you sustain it financially?
Yes. Yes. Absolutely. Absolutely. Yes. Got to do both. Got to do both. Yeah.
Okay. Thanks, Ryan. That's part one.